You're listening to Soundside. I'm Jed Kim, Soundside's editor, in for Libby Dankman. Roger Rogoff is the new U.S. Attorney in the Western District of Washington. Or wait, no, I mean he was. He started this morning, but then he was fired by the president less than an hour after getting sworn in. Rogoff is a former King County Superior Court judge and a former federal prosecutor. He was appointed to be the U.S. Attorney by the Western District's federal judges. His firing by Trump has set off a big legal fight. It's a rough first day on the job for sure, but none of this was a surprise. Here to explain why is Liz Porter. She's a law professor at the University of Washington, and she joins us now. Thanks for speaking with us, Professor Porter.
Thank you for having me.
So first off, reading about this felt like a giant civics lesson this morning. Can you give us some of the background into the drama that led to Rogoff's appointment and subsequent firing?
Yes, I can. And I do think it's fairly dramatic, but it's very wonky as drama goes. Essentially, the U.S. attorney is the head prosecuting attorney in our part of the state. This is for federal crimes. So not just criminal actions, but also civil cases, but things like major drugs crimes, sex trafficking crimes, major fraud crimes. And because this is a very important position, under our constitutional plan, these U.S. attorneys need to be appointed by the president and then confirmed by the Senate, just like, for example, Supreme Court justices. And all of this drama is happening because President Trump has not nominated anyone to serve as the U.S. attorney here in the Western District of Washington. So that's what's generating the drama. Typically, the president will nominate someone, and it might take some time, and they might have to go back and forth, but by now we would have an actual permanent U.S. attorney with the advice and consent of the Senate.
Yeah, I understand that there was somebody that they had in mind, Neil Floyd, who was serving as kind of an interim position. Why didn't they put him up?
Well, he's actually somewhat serving in that position right now, but the president didn't nominate Mr. Floyd for a few reasons. I think the principal one is that by long-standing tradition, the senators from a state where a U.S. attorney will serve have the right to kind of veto or give a thumbs down to a potential U.S. attorney candidate. And I think it was correctly believed that Charles Neal Floyd wouldn't survive that scrutiny by Washington's two senators. This may sound strange, but it's a way for these offices to simultaneously represent federal policy dictated ultimately by the president, right? Federal executive policy, while remaining sensitive in our huge country to local priorities.
That was something that surprised me. So that power to veto the president's pick for U.S. attorney, that's actually baked into the role of the senators?
I think it's a constitutional tradition. It's not a statute. It's not written in the Constitution. It's just a long-standing norm. But you can see that all the senators from all over the country, regardless of their political persuasion, have an incentive to maintain that norm.
So, I mean, we are dealing with an administration that famously is rejecting norms. So all of this doesn't seem like that much of a surprise, considering the way that the Trump administration has done this elsewhere in Washington and around the country. How much fight has there been over these U.S. attorney appointments?
This has been happening in many states. It's been happening in Wisconsin. It's been happening in New Jersey. It's happening here. This has been a problem in California, in Central District of California. So Washington is not the only place where this is arising, but the details have varied a little bit from region to region. So here in the Western District, Charles Neal Floyd was the interim U.S. attorney. And when the period allowed by statute, by Congress, for serving as an interim U.S. attorney expired, rather than nominating either him or somebody else to become the permanent U.S. attorney, they simply changed his title to First Assistant U.S. Attorney. And actually, the last time I looked on the website, which was maybe yesterday or the day before, you can tell that there's been no fundamental change from when he was serving as the interim U.S. Attorney, because they didn't even alter his website biography. They just changed the title at the top. So this has been a change in name only. If you were to ask the kind of obvious follow-up question, First Assistant to whom? There is no answer, right? Because there is no U.S. Attorney. There's only the First Assistant U.S. Attorney.
Got it.
That's the problem. And Congress also recognized that there could be a breakdown in these various processes, and it passed a statute saying once the interim U.S. Attorney has fulfilled their maximum number of days, if the president hasn't nominated and gotten confirmed a permanent replacement, the judges of the district court, the district court judge, the chief district court judge, can appoint a replacement. That person is only temporary, pending a confirmed presidential nominee. That person is not intended to be a permanent replacement. It's a stopgap measure. And that's what happened this morning, was a stopgap, very qualified, excellent, generous person stepped in to fill that gap, but only filled it for several minutes.
Right. You're right to talk about how wonky this is, but it is interesting and I'm sure thrilling to people who are fans of procedure. I do want to ask, though, so this is all about getting somebody into that stopgap position. What about firing? What arguments does Trump have for being allowed to fire Rogoff, and what are the arguments against?
Actually, I don't think it's very controversial that the president is allowed to have U.S. attorneys who suit his priorities at some level. So I don't think the firing is very controversial. It's really the appointments it's the front part of this question. How to get somebody into that position, who holds that position, that's controversial. The Supreme Court has recently emphasized the fairly broad, if not infinite, power of the president to fire executive branch officials who do not suit his priorities. So I think the firing is, I don't know. Certainly there'll be a lawsuit. The lawsuits have been brought often by people who are charged with crimes in these districts, and they'll bring a lawsuit arguing that their indictment is invalid because it was brought by an unconstitutionally appointed official. And that's kind of complicated, as you can imagine. So is there a problem here? Yes. Is the path forward clear? I would say no. Also, I don't know if this resonates with you, but all of these legal proceedings and the debate over this will take time. So we're already pretty far into the Trump administration, and there is no permanent nominated, confirmed U.S. attorney here in the Western District. And there's not a prospect of having such a person in the near future. So there's a constitutional question on one hand, and on the other hand, there's just a practical question. The delay and the time that it's taking mean that we are living in this kind of quasi-constitutional limbo for a long time.
Yeah, what happens when there isn't a U.S. attorney in office?
Well, I don't know. I mean, as a practical matter, what's happening now is that the first assistant U.S. attorney is operating in everything but title as the U.S. attorney. That's what's happening. I mean, there are many hardworking people in these offices. This isn't a question of the qualifications of the individuals, either of Mr. Floyd or of anybody else. This is a question about the blueprint of the nation in terms of dividing powers for choosing these really impactful positions between the branches of government.
So then Floyd, as first assistant, was not replaced when they appointed Rogoff. He stayed in that first assistant position.
He did. I mean, it all took place in a matter of minutes, so I'm not sure there would even have been time. Like, I don't know that there was a detailed plan made. And
Okay.
it was predicted that this would happen. The firing was predicted. I think it happened perhaps a little bit more rapidly than I would have expected, but maybe within a few hours, I expected this to happen.
If this was all so expected, and I mean, Rogoff is somebody who, in a previous position, was investigating killings by police officers. So I could see how that would be kind of antithetical to the law and order messaging of the Trump administration. So if this is all kind of expected and what's why do this? Why put him up?
I mean, actually, I think he's a vastly qualified, experienced attorney and former judge who has all the qualifications to run the U.S. Attorney's Office. I think that the district court took its time looking at candidates who would be willing to embrace this risky position and yet and simultaneously, who were manifestly qualified to take on this role. So the court was acting in accordance with the statute to do the best thing that it could do.
Mm-hmm.
And the breakdown is essentially with the Trump administration. Also, I don't know if you can understand this or if this is too wonky, but in my view, the part of the government that's really not being respected here to some extent is Congress, because the Senate has the right and the responsibility under the Constitution to provide advice and consent to these high important nominees like U.S. attorneys. And it's being deprived of the ability to consider candidates and either approve them or not approve them on the one hand. And then Congress passed a statute saying, well, if this process breaks down, here's a plan. We'll let the judiciary take care of it, filling this in until we can comply with the constitutional process. And so Congress thought about this and made a plan. And by firing this person summarily, you're once again kind of disrespecting the congressional view of how all of this will go. So there are really the three branches of government involved in this.
So it was an end run to get around Congress, and then kind of an end run to get around the administration's pick for the U.S. Attorney role. And I am struggling to see what the result of this is. I guess we're going to find out in the future. In the meantime, are there any consequences? Like, is any work not able to get done because there isn't an official U.S. attorney?
That's a really hard question to answer because a different U.S. attorney might have different priorities, make different charging decisions, investigate different crimes. So each individual U.S. attorney, in consultation with the Department of Justice, right, and also with kind of local priorities, will be making perhaps different decisions, setting different priorities, but it's hard to really imagine what that alternative would look like. And at some point, there is a question of whether courts will find that indictments issued under a person who's not constitutionally authorized to lead the U.S. Attorney's Office might not be enforceable. But you can also understand how courts and really respect the work of the many people who work at the U.S. Attorney's Office, doing really important things, and don't want to lightly trample over that. Mm-hmm. That's why it's a difficult situation.
In the meantime, for Rogoff, as he's fighting his firing, where does that go? Is there a court of appeals? Does that go to the state Supreme
That's
Court?
A good question. There was an analogous situation in the Central District of California where there was a judicially appointed U.S. attorney who was fired. And in considering the lawsuit challenging that, ultimately all of the judges of the district court had to recuse themselves because they'd been implicated in the decision, involved in the decision to choose the replacement. And a district court judge from the District of Hawaii came to the Central District of California and sat by designation to hear those cases. And I would imagine that something similar to that would happen here.
Oh, wow.
The judges who helped make this decision would not be the ones who would evaluate the decision for reasons of conflict of interest.
Thank you for laying that all out for me. Elizabeth Porter is the James W. Mifflin University Professor of Law at the University of Washington. Thank you so much for speaking with me about this today.
Thank you for having me. I appreciate it.
Thanks for listening to Soundside. Don't forget you can listen live on KUOW 94.9 FM Seattle at noon and 8 p.m. Monday through Thursday, or anytime online at KUOW.org or on your favorite podcast app.